tools and techniques to expedite MACT cases. This is course number 7, R-5, and the target groups are presiding officers of MACT and 1 officers from other districts dealing with MACT cases. So the Judicial Academy is holding this third, we will call, interactive online training program. And as it always happens, that it is the compulsion and urgency of the time that is a harbinger for innovations. So we are in a time, we are in a such troubled time, which has given this innovation and which is expanding. It has both plus and minus. Plus in the sense that much of time of the officers in commuting to the district is saved. And but we feel that this mode cannot be a complete substitute for the direct interaction which takes place in classes. Be that as it may, today we have assembled here, and I am really happy to welcome in this session Sri A.N. Krishna Swamy, Advocate, Karnataka High Court. He has been a member of the Rule Committee of the new Amended Act, a very experienced person as far as the MACT cases are concerned. And we had the privilege to have him in our academy on the last occasion when we had a conference on MACT cases. And the second, the other resource person, this eminent and distinguished resource person, is Mr. Ashok Priyadarshi, very well-known name in Jharkhand judiciary. He comes from Patna High Court and has been a regular faculty here as far as motor accident claim matters are concerned. So basically, I remember a few days back, there was a headline in Times of India that even in these times, 200 migrant laborers died in road accident. And this is very revealing in the sense that when all the motor traffics were not there on road, despite that, there were so many loss of life on roads. And that brings us to the urgency of the accident claim matters. So here we will prefer to hear there are very larger issues. The two important issues are, in 2019 we had the new Amended Act, but since the rules have not been framed, a part of the compensation matter has not been really come into force. So this is one issue, and the law that is evolving as far as the compensation matter is concerned. This is one issue. The second issue is we will expect that our resource persons throws light on how to expedite matters in cases where the trials are being held by virtual courts. So if we can evolve some new techniques regarding that by interaction and exchange. The officers, we invite questions on chat box from all the officers who have joined us, and so that the resource persons can respond to the questions posed by the officers with regard to the accident claim matter. So with these words, without encroaching on the valuable time, I request Sri A.N. Krishna Swamy to make his presentation and enlighten us on the topic. Thank you.
Thank you. Good morning, everybody. This is the second occasion I am able to interact with my dear friends and judicial officers. And the topic that is assigned to me today is the motor accident claim cases, past, present, and future. When I started my practice in 1975, I was handling MACT cases by virtue of 1939 Motor Vehicles Act. Subsequently, in 89, amendment came and a new Motor Vehicle Act was introduced, that is 1988 Act, that is popularly known, but it came into effect from 1/7/1989. Now, we are in the course of getting one more amendment. Amendment is 2019 Amendment Act. Chapter 11 and 12 are not yet notified. That is the reason why we have to fall back on 1988 Amended Act to deal with all MACT cases as of today. In fact, when I was going through these provisions, I felt that the place and period of limitation where an MACT case could be filed, and what was the limitation? We will try to analyze this from 1939 Act and also 88 Act and 2019. Earlier, there was no motor accident claims tribunal. Section 110 of MV Act, as it then stood, provided for an opportunity to the claimants to move a civil court, and the period of limitation granted was 2 years from the date of accident. With effect from 16 to 1956, they thought that motor vehicle accident cases deserves to be decided by a tribunal. Therefore, instead of original section 110, they brought in 110 to 100F were introduced. When it was brought into effect in 1956, the period of limitation to file a case before MACT was 2 years only. There was no provision to condone the delay. But 1970 March 2nd, the period of limitation was changed to 6 months, and a provision was also provided to MACT to condone the delay, provided it gets satisfied with regard to the genuine reasons. This was the position under old Act, 1939 Act. Then under 1988 Act, which came to effect from 1/7/1989, the law provided 6 months time with the power to condone delay. This power was given to MACT. This was under section 166(3) of MV Act. The provision that gave power to MACT to condone delay to some extent created havoc. Even after a lapse of 3 years, 5 years, 8 years, MACT used to condone the delay. Representations were given to amend it. However, the Parliament thought it fit to delete 166(3). Instead of deleting provision relating to condonation of delay, the entire provision of 166(3) was deleted. That was done with effect from 14/11/1994. From 14/11/1994, there is no period of limitation. A claimant had benefit to lodge a claim at any point of time. Very recently, Supreme Court held that in a stale case, it becomes a stale case if it is filed beyond certain period. This was the position from 14/11/1994. Lot of agitations were there with regard to this provision. And Motor Vehicles Amendment Act considered this aspect and introduced once again 166(3). It makes a mention that no application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. By virtue of 2019 amendment, 6 months time is granted to a claimant to approach motor accident claims tribunal. Strangely, there is no power to MACT to condone the delay. This is one vital aspect under 2019 Act. This was with regard to period of limitation. And with regard to place where it could be instituted, where a claim petition could be instituted under old Act, 1939 Act. Claims tribunal having jurisdiction over the area in which the accident occurred. That was the place where claimants could have filed a claim. Was under section 110(8) with bracket 2 of 1939 Act. But in 1988 Act, claims tribunal having jurisdiction over the area in which accident occurred was retained. 1988 Act also the same was retained. But with effect from 14/11/1994, the Parliament thought that this may not be correct. Therefore, they changed it. They substituted with effect from 14/11/1994. This is 166(2) of MACT. Every application shall be made at the option of the claimant, either to the claims tribunal having jurisdiction over the area in which the accident occurred. This was available in 1939 Act and also 1988 Act. That is retained. This is first option, but the option is given to the claimant. He can file it area where accident occurred, or to the claims tribunal within the local limits of whose jurisdiction the claimant resides or carries on business. This second option is also given. Or within the local limits of whose jurisdiction defendant resides. An important question arose whether a claimant is permitted to make a claim petition before a tribunal where insurance company has a branch office or any other office, operating offices. According to me, that was not the intention, because insurance company cannot be termed as a defendant in a proceedings. The language used is where local limits of whose jurisdiction the defendant resides. An insurer is not required to be made a party from the beginning. Therefore, we cannot treat an insurance company as a party to the proceeding. I will, if time permits, I will explain this aspect at a later stage. But in 2019 Act, that is Act 32 of 2019, same provision is retained. But place of business of insurer not mentioned in the 88 Act and also under the present Act. Therefore, the very same provision as contained in section 166(2) is retained. Now, with regard to claims tribunal, some interesting aspects are available. As per section 110, earlier it was claims has to be filed before a civil court within 2 years from the date of accident. This was the first aspect. Subsequently, MACT was constituted. from 16 to 1956, the claims tribunals were formed, and claimants could have filed it before claims tribunal. In 1988 Act, for the purpose of adjudicating upon claims for compensation in respect of accidents involving the death of or bodily injury to persons arising out of use of motor vehicles or damages to any property of a third party so arising or both. The same thing which was available in a old act is retained, and in 2019 Amended Act also the same thing is retained. But with regard to the qualification of a member who can occupy motor accident claims tribunal, 1939 Act provided that a person shall not be qualified for appointment as a member of a claims tribunal unless he is or has been a judge of a high court. The importance given for a claims tribunal was that a sitting high court judge or a retired high court judge could become a member. That is the requirement. Second, as B, he is or has been a district judge. If a person is a district judge or a retired district judge, he can become a member of motor accident claims tribunal. C, this is most interesting, is qualified for appointment as a judge of the High Court. This was in 1980, 39 Act. Is qualified for appointment as a judge of the High Court. According to me, C provided for appointment of advocates as members to motor accident claims tribunal. Minimum qualification for a advocate to become a High Court judge is practice of 10 years. With that intention, it was introduced earlier. Now, some changes are also made with regard to these qualifications. A, B, both are retained. That is, a High Court judge or a retired judge, a district judge working or a retired district judge. C, there is a change under section 166(3). Is qualified for appointment as a High Court judge. Added, one more thing is added, or as a district judge. This is introduced to see that an advocate with 7 years practice also can become a member of motor accident claims tribunal. However, the reality is something else. Practice is that senior civil judges are also given charge of holding MACT membership as they are qualified to become district judges. Is what is happening in Karnataka. All the MACT members are civil judges, senior division, and district judges are also handling in some cases, some parts. Now, with regard to, we will come to grant of compensation. Grant of compensation is under liability without fault. This is chapter 10 of 1988 Act, where section 140 is there. The 25,000 rupees is for death and 12,000 rupees for permanent disablement. Earlier 1939 Act also we had similar provision. 92A was introduced. A, B, C, D, E. This was introduced, where for death 15,000 rupees was the compensation payable. For permanent disablement, it was only 7,500. This is under Old Act and also 1988 Act. I will tell the reason why this provision of liability without fault was introduced. In 1977, Minu B. Mehta's case reported in ACJ 1977, page 118. Three judges bench of the Supreme Court felt that no compensation is payable if claimants fail to prove and establish negligence. Therefore, some provision must be made to pay some amount to them, even without granting of compensation, without liability, without a fault liability. That liability is called as liability without fault. This was introduced, but we may have to look into the latest act, Amended Act. This is Chapter 10 itself is omitted. Now, we will come to one more provision which granted compensation, special provisions on the basis of structured formula. This was not there in 1988 Act from 1/7/1989. This was also introduced because Supreme Court, in more than 3 decisions, wanted a provision to be made for grant of compensation on structured formula without going to the proof of negligence. Therefore, with effect from 14/11/1994, this was introduced. 163A was introduced to grant compensation on structured formula. We all know Deepal Bhai Girish Bhai's case of the Apex Court, which dealt with this, and also Trilok Chandra's case, 3 judges bench made a comment that the schedule attached to 163A contains a lot of mistakes. Subsequently, Parliament thought we will remove it. They removed that schedule. Instead of various compensation, they introduced a sum of rupees 5 lakhs payable in respect of death. Proportionately, compensation was payable to injury cases also. That 163 is not available now. Now, there is one provision numbered as Section 164 that is introduced. That also grants compensation under structured formula, 5 lakhs and 2.5 lakhs. I will come to that a little later. The other provision is hit and run. It was not there in 1939 Act. However, it was introduced in 1988 Act. Now, by virtue of Section 162, insurance companies under provisions of this Act for treatment of road accident victims, including during the golden hour. These are the amendments that the Parliament has thought it fit would find a suitable place in Amendment Act. The moment it is notified, we will have the benefit of this. And there is one more scheme for cashless treatment. One more section under Amended Act is Section 164, where payment of compensation in case of death or grievous hurt, that is in consonance with 163A, 5 lakhs and 2.5 lakhs are given. But the grievous hurt is as per Section 320 of IPC. that we can find it under section 145C of Amended Act, New Act. There is one more provision, 164A. This deals with is a scheme for interim relief for claimants. And 164B is motor vehicle accident fund. This is the reason why it is getting delayed. Rules are not yet formed. Whatever rules that we have prepared and submitted, it is under the consideration of Transport Ministry. And they have formed one more committee to go into this aspect with IRDA. They may come out with this in December 2019. There was an assurance by March or April, the rules also would be published. However, because due to these COVID conditions, it has not come. In all probability, I expect it to come by October. Now, we have got one more interesting aspect is grant of compensation. Under New Act, there is a settlement is possible. Settlement under 149. Failure to accept if a settlement is proposed by insurer, that this is the compensation payable. If the claimant wants it, yes, this is a just compensation, they may take it. If they refuse it before MACT, this settlement would take place only before motor accident claims tribunal. Such an offer also would be made in a case where claimant has already instituted a claim petition. If that is accepted, the matter comes to an end. This offer of insurer could be rejected by a claimant. Then MACT would adjudicate upon the quantum of compensation that is payable. Limits of liability, we will come to this, and in fact this is most interesting. People said in 1939 Act, for a death by use of a lorry, if a death had caused by use of a lorry, a certain amount was fixed. Occupants of bus, depending on seating capacity, compensation was determined. In respect of occupant of a car, motor cab, a fixed amount was there as compensation. I will read out the salient features of 1939 Act in this behalf. Under 95(2)(a), goods vehicle, maximum compensation payable was only 50,000. Passengers up to 30, maximum compensation payable was 50,000. Passengers up to 60, 75,000. Passengers carried more than 60, that is carrying capacity, 1 lakh. For a motor cab, limit of liability was only 10,000 and third party property damage was restricted to 2,000 rupees. Under 1988 Act, under 147(2), as far as these third party liability is concerned, was amount of liability incurred. Whatever liability is there, that was made payable by insurance companies by virtue of 147(2). As far as third party property damages were concerned, from 2,000 rupees that was enhanced to 6,000 rupees. Now, by virtue of this amendment that is brought, whether there will be restriction with regard to third party liability or not is the question. We will have a look at section 147(2) of Amended Act. Under 147(2), this is what is contemplated. Central government shall prescribe a base premium and the liability of an insurer in relation to such premium for an insurance policy under subsection 1 in consultation with IRDA. The central government now has to fix the base premium, and the liability of insurance company also would be fixed. Liability would not be unlimited by virtue of 147(2). It would be once again restricted as contained in 1939 Act. One more aspect with regard to the liability. As far as base premium that the central government is going to fix and the extent of liability would be fixed by them. Nothing prohibits the owner to take out a policy to cover unlimited risk as prevailed under 1939 Act. The same thing has come back once again. Under 147 of 1988 Act, there was one peculiar aspect. Two things were excluded. Number one is a policy of insurance is not required to cover the risk of employees. That was the first restriction that was imposed under 147. Second restriction was it is not required to cover a contractual liability. These were the two things. Up to 1956, there existed no liability to cover the risk of employees. Subsequently, it was introduced. To see that at least certain employees doing certain job would get compensation, at least to the extent of Employees Compensation Act or Workmen's Compensation. That was there in vogue. Then only certain employees were permitted. Under 1939 Act, it also mentioned with regard to number of persons who could be carried, 6 coolies in a heavy goods vehicle. That was the restriction imposed. That is removed under 1988 Act. Under 1988 Act, if he is a driver engaged in driving, if it is a transport vehicle, conductor or ticket examiner on the vehicle. C is if it is a goods carriage being carried in the vehicle. This difficulty was there. How many people could be covered? Being carried in a goods carriage means any number of persons also could be included. Now, cabin capacity and other things has come by virtue of decisions rendered by the Supreme Court. Therefore, by virtue of that, now by Amendment Act, that is removed. This proviso itself is removed. However, the driver's risk and also other co-workers on a transport vehicle is introduced in 147 definitions itself. They become third parties. And in fact, hitherto, it was restricted liability under Employees Compensation Act. But under Amended Act, they are treated, the driver and also co-workers of a transport vehicle are treated as third parties. In fact, this is a new venture. In fact, runs contrary to the law of torts. An employee is a representative of the owner. His risk is not required to be covered because he would be traveling as representative. Because whether he owner or representative, risk is not required to be covered. Both are the same. However, that is some exceptions were carved out. Now they are given power to get compensation under 1988 Act. By virtue of Amended Act, An advantage to employees is that they can claim it as third parties, provided that is also restricted. In a transport vehicle, the driver and any other co-worker on a transport vehicle is covered. Now, the most interesting aspect is Section 149. Insurance companies had a grievance, and we are prepared to pay the compensation as if I am a judgment debtor by virtue of 149(1) of MV Act. But an insurance company is not required to be made a party, and I'm bound to pay the compensation as per the provisions of 149. Why, when you provide me some defenses to avoid liability, in fact, that defense, according to some of the advocates, is that it is a defense given to an insurance company to avoid liability to pay compensation to the claim of claimants. A plain reading of 149(2) would make it clear. Supreme Court also accepted it. In Swaran Singh's case, Supreme Court accepted that it is a defense. However, Supreme Court was considering 149(4) and 5 of MV Act. Under 149(4) of MV Act, it felt that the provision relating to pay and recovery is mentioned. I will read this 149(4). The proviso attached to 149(4). It reads, provided that any sum paid by the insurer in or towards the discharge of any liability or any person which is covered by the policy by virtue only of this subsection shall be recoverable by the insurer from that person. And subsection 5 was, if the amount which an insurer becomes liable under this section to pay in respect of a liability incurred by a person insured by a policy exceeds the amount for which the insurer would, apart from the provisions of this section, be liable under the policy in respect of that liability, the insurer shall be entitled to recover the excess from that person. This proviso to 149(4) and subsection 5 made Supreme Court in Swaran Singh's case to adopt the same analogy and make insurer to pay the compensation and recovery. Now, by virtue of amendment in 2019 amendment, 140 this proviso and also subsection 5 are removed. If that is removed, question of pay and recovery also would go. Insurance company will have these defenses: A, B. No, whether only A and B are the defenses or something else is also added has to be looked at. Under 1988 Act, it was defense of non-receipt of premium was not included as a ground. Now, non-receipt of premium is added as a ground under 149(2)(c). The effect of these amendments, one is it would the liability of third party would get restricted for an insurer. Second one is paid recovery orders that were being passed for violation of 149(2) would go. Number 3, even if non-receipt of premium is a ground on which insurance company can say that there is no policy and no liability. And 149(6) is included under explanation. And insurance policy who has to establish the policy of insurance? Normally, the MACT members used to say that number is given, you have to establish, and the liability was always on insurer to establish. Views of that nature was also taken by most of the MACTs. Now, by virtue of amendment brought to 2018, insurance policy under 149(5), it has to be established by owner of vehicle. Owner of vehicle has to establish it. Now, we can try to analyze whether section 50, 150 of MB Act, 151, 152, 153, 154, 155, 156, and 157 will have the same meaning. According to me, they have not changed these sections. But most of us have not read these provisions also while handling MACT cases. Under the requirement of law is, under 146, no person shall use a motor vehicle on a public road without there being a policy of insurance. This is the requirement. But under section 147(3) of MV Act, the requirement was not with regard to the policy. The policy shall be of no effect for the purposes of this chapter. In fact, for this chapter, they felt that policy of insurance is not sufficient. What was required was a certificate of insurance. A certificate of insurance is a requirement, and that will be prescribed by the central government. Now, two documents are made known by 147(3). One is a policy of insurance. Second one is certificate of insurance. We all know under 145, we have got a cover note also. The policy of insurance is defined under 146, 145D, and under 145B, certificate of insurance is defined. The certificate insurance would be the basis on which an insurance company would pay the compensation. The insurance company has no say in the matter. They have to pay the compensation, whatever is stated in the certificate of insurance, including the extent of liability. That is not changed under the new act. If liability is there, as per amended act, we have to pay the insurer has to pay the compensation as provided by central government in respect of base premium and also the amount that is fixed by central government. That would also get changed from time to time. This is the second aspect. One more aspect that I wanted to bring was the under old act, 1939 act. Earlier there was no provision to grant interest. Under old act there was no provision. Therefore, no interest could be granted by MACT. 110cc was introduced to grant compensation as per now 171 in 1988 Act. an argument was there that when MACT determines compensation under Section 168 of MB Act, it has to grant just compensation. Whether cost and also interest forms part of determination of compensation. Judges said, no, you are granting compensation under Section 168 and it is not interest or cost. That has to be separately granted. That is the reason Section 171 was introduced. One more interesting question that has cropped up is whether motor accident claims tribunal can grant costs. Interest could be granted. Whether cost also could be granted. In fact, in CPC, we have Section 35 and 35 capital A. Here, under Motor Vehicles Act, they have provided one provision, that is Section 172. That is just like Section 35A of Code of Civil Procedure. 172 of MV Act, 172 of 1988 Act, award of compensatory costs in certain cases. Any claims tribunal adjudicating upon any claim for compensation under this Act may in any case where it is satisfied for reasons to be recorded by it in writing that policy of insurance is void on the ground that it was obtained by the representation of fact which was false in any material particular. This is your granting, power is granted to award compensatory costs in respect of a defense that is given to an insurer under 149(2)(b). This is the defense. If a defense is established, not only insurer would be avoiding his liability to pay, but also exemplary costs. They are entitled for exemplary costs under 172 is maximum is 1,000. And the second one, this is most important, is any party or insurer has put forward a false or vexatious claim or defense. Any party, whether an insurance company or a claimant, if they have put forward a false or vexatious claim or defense, then also compensatory costs could be awarded, but not regular costs. As far as grant of regular costs are concerned, no provision is made in 1939 Act, 88 Act, or in the Amended Act. Therefore, MACT can proceed to grant compensation by virtue of these provisions only. Grant of compensation towards loss of dependency or for injuries, whatever is payable, and then interest that could be awarded, and also compensatory costs. Now it is 11:15. Should I devote for question answer or shall I continue?
Sir, you can continue, sir. You can wind up. You can continue at.
I will wind up by 11:30.
No problem.
Okay, I will continue this 11 up to 11:30. I was considering Section 170 of MV Act. While reading Section 170 of MV Act, I understood the enormous power that MACT has got. Not only enormous power, the duty cast on MACT. I will read the salient features of Section 170. Impleading insurer in certain cases. Therefore, insurer would not be a party to the proceedings is also done by virtue of this. There, in the course of any inquiry, the claims tribunal is satisfied. In fact, under Section 168, 169, and 170, The word used is inquiry, not enquiry. Enquiry is asking somebody something about thing and be done with that. But inquiry is investigating procedure that deserves to be followed. There are two things where in the course of any inquiry, the claims tribunal is satisfied. Here is a case, here is a provision where it wants MACT during the course of inquiry, that is while it is determining, there is collusion between the person making the claim and the person against whom the claim is made. I am not a party, I will be paying the compensation. If there is collusion is unearthed by MACT, in fact, it is the duty of MACT to hold an inquiry and say that no misrepresentation is committed. And the courts are not taken for a ride while getting compensation or while conducting a claim case. The person against whom the claim is made has failed to contest the claim. This is second aspect. If that person has failed it to contest the claim, then also it has got a right. And in fact, when I brought this to the notice of some of the judges of Karnataka High Court, earlier they were reluctant. They said that it is not the duty of MACT. MACT would not inquire into these aspects. Party has to plead his case and adduce evidence. And in fact, we all know in Sheila Datta case, 3 judges bench of the Supreme Court has held that it is not an adversarial proceedings. It is inquiry that is required to be made by MACT. Therefore, a lot of responsibility is cast on members of MACT to hold an inquiry. This is 168 is, they say that after on receipt of an application for compensation made under section 166, the claims tribunal shall, after giving notice of the application to the insurer, 166, 68, notice has to be given to an insurer. After giving notice of application to the insurer and after giving the parties, including the insurer, an opportunity. And in fact, insurance company is not a party, is not required to be made a party from the beginning. Can be understood by reading section 168. Section 169 would give ample power to MACT. MACT would get all the powers by in holding any inquiry under section 168. The claims tribunal may, subject to any rules that may be made in this behalf, follow such summary procedure as it thinks. The claims tribunal shall have all the powers of a civil court for the purpose of taking evidence on both and of enforcing the attendance of witnesses and of compelling the discovery and production of documents. Wherever MACT wants these documents to be produced, that it can compel anybody to produce it. So much of powers are given to motor accident claims. In fact, motor accident claims tribunal, they will follow summary trial, but according to me, the enormous work that they are doing it, they will be assessing medical evidence, they will be assessing negligence, they will be granting compensation as a chartered accountant, they will be assessing the evidence that is made available by claimants and also the insurance companies. And in fact, I reasonably feel that the role of a motor accident claims tribunal member is enormous. An ordinary person cannot occupy such a post. That is the reason why qualification to become a member is shown as a High Court judge, sitting or past district judge. Therefore, I always feel that the motor accident claims tribunal members have got enormous power to do this. Now, one more aspect is Section 171 of MV Act. 171, award of interest where any claim is allowed. When any claim is allowed, our interest could be granted. This is one section which would indicate that where any claims tribunal allows a claim for compensation under this act, such tribunal may direct that in addition to the amount of compensation, simple interest, in addition to the grant of compensation, because it is an additional amount to the compensation even according to section 171. Therefore, award made under 168 is not inclusive of interest. In addition to the simple interest could be granted at such rate and from such date, not earlier than the date of making the claim. Two other aspects that may crop up is prior to the filing of claim petition, date of claim petition, interest cannot be granted. There is embargo. But MACT has got power to grant interest from any date if evidence is deliberately not adduced by a claimant, or for some other reason they have dragged on the matter, or claim petition was dismissed, later restored, for that period or any other thing. MACT has got discretionary power to grant from such date. I agree with that proposition. But as far as rate is concerned, what would be the correct rate of interest? We have got cases where Supreme Court has granted interest at the rate of 12%, 9%, 8.5%, and in some cases 6%. Which rate has to be followed by MACT? This would be a question. Some rate must be there, consistency must be there, because a person who suffers injury would get 9% interest under the hands of one MACT, another person would get only at 6%. The same compensation. Why that should be denied? Therefore, I always feel that there must be some uniformity as far as this is concerned. There must be maximum limit also must be imposed as far as rate of interest is concerned, because this compensation is not a debt. In respect of future loss that is being granted now by virtue of multiplier method, Justice M.N. Venkatacharya, who became Chief Justice of India, he had passed a judgment in reported in Geeta's case when he was sitting as a district judge, a division bench, Karnataka High Court. He said the maximum rate of interest payable is 6%. This is one limb of argument. Other 3-4 division bench decisions of various courts also would indicate 6% is the correct rate. But one more provision which I want to bring it is to your notice is that under section 149(1), there is some indication. 149(1) of MV Act may kindly. 149(1) of earlier Act, 88 Act. I will come to the last portion of section 149(1). Decree any sum not exceeding the sum assured, payable thereunder, as if he were the judgment debtor in respect of the liability, together with any amount payable in respect of cost. 149 would indicate that in respect of cost, if some cost is imposed, that is payable according to 149(1). But no other corresponding provision charging section is made available under other provision. And any sum payable in respect of interest, any sum that is payable in respect of interest on that sum, that is compensation amount, by virtue of any enactment relating to interest on judgments. This motor accident claims tribunal members may have to decide how this has to be understood. In interest, they say that interest has to be paid on that sum, that is compensation amount, by virtue of any enactment relating to interest. There must be some enactment relating to grant of interest, not on claim, on judgments. And I was arguing this, I read this particular 149(1) before a division bench consisting of Will Nazir, who is now a judge of Supreme Court. He said, Krishna Swami, you stop it. I have understood it. You refer only to one section of Code of Civil Procedure. That is the only enactment available towards grant of interest on judgments. And according to you, interest can't be granted more than 6%. Is it your case? Yes, I said yes, that is my case. It cannot be granted more than 6% by virtue of Section 34 of Code of Civil Procedure. And one aspect is, we will restrict it to any interest rate, whether it is 6%, 5%, 10% or 7%, let it be uniform. Therefore, anyhow, we have got one enactment relating to grant of interest where maximum up to 6% interest could be granted for these cases. I feel that provision could be made use of, and interest tax section 3 may not be applicable. And some judges of Karnataka High Court, they have given judgments in this behalf. They hold that section 3 is not applicable, section 34 of CPC is applicable, and maximum rate of interest that could be paid is 6%. But anyhow, this has fallen for consideration of Honorable Justice Midda of Delhi High Court. He had issued notices to GAC and other companies also to express their views. We have already expressed our views that interest, and a decision would be taken by him. And ultimately, the Supreme Court may have to decide. So far, in none of the decisions, Supreme Court has referred to section 149(1) for grant of interest. This is, I think, it is 11:30 now. My time granted to me is over. I do not want to transgress the time granted to me.
Sir, so far our next resource person has not joined, so I will request you to continue. And,
I can continue. In fact, I don't mind continuing.
And we have also received one question also, sir. It is on the chat box.
Can anybody read it now?
Yes, sir. Yes, sir. This
Please
question
read.
comes from Sri Ashok Kumar, PO MACT Hazaribagh. I wish to refer to the point raised that jurisdiction cannot be determined on basis of the insurance company party carrying on business in a district. The Honorable Apex Court in uh, Mantu Sardar versus Oriental Insurance Company 2009 Volume 2 SEC 244 and subsequently in Malti Sardar versus National Insurance Company have been pleased to make a mandate that there is no bar to a claim petition being filed at a place where the insurance company, which is the main contesting party in such case, has its business. In such cases, there is no prejudice to any party. There is no failure of justice. This authority shows that jurisdiction to file claim cases are in every district where the insurance runs its branch office and carry on its business. Sir, your views,
Yes,
please.
sir, I have understood. Yes, I have understood. The decision in Mantu Sarkar's case was in respect of a migrant laborer. He was working at a place. Thereafter, he shifted and he filed a place where he was earlier working. Supreme Court said that it may not cause prejudice to the insurance company, and he was a poor man. With that condition, with those observations, it passed an order in Mantu Sarkar's case. it presupposes that place where that person worked would also be taken into consideration. But statute provides that where he resides or carries on business, that is claimant, not the defendant. Number one. Number two is, we must forget that insurance company is a party to the proceedings. Insurance company is not required to be made a party, and it is only an OTC. That is the reason why Supreme Court in Sheila Datta's case, in respect of Nicoletta Rohti's case, when the matter had come up before 3 judges bench, Supreme Court said, Sheila Datta's case, that insurance company is only an OTC. That is what 149(2) also would indicate. 149(2) would indicate that the insurance company under 149 would pay the compensation as if he is a judgment debtor. But it can become a party. Insurance company can become a party provided that the notice issued to him would indicate that it has got a defense. If it comes out that it has got a defense, that is to defend the action. If insurance company feels that it has got a defense, it can defend the action of the claimant, it can become a party to the proceedings. This is the first time insurance company would become a party. Insurance company, after receipt of notice, can request MACT, please make me a party to the proceedings. Though insurance company is only a notice, not a party, please make me a party. That would be a request to avoid liability. Therefore, second one aspect is, insurance company would be implemented as a party under section 170 by MACT itself. On its own, it would be doing it. But what is happening now is, all claimants, in order to ensure that they will get compensation, make insurance company also a party to the proceeding and notices are served. That is what is observed by 3 judges bench of Supreme Court in Sheila Datta's. Therefore, insurance company is not a party. But one question was put. That is a relevant question. What prejudice it causes to an insurance company? At each district, insurance companies will have. In your area, MACTs are, members are at district judges. Normally, it would be conducted before district places, headquarters. But in Karnataka, they have given powers to civil judges. Almost all talukas, they have got the civil judges. They are conducting MACT cases. This is one aspect. As far as public sectors are concerned, they have got officers. But as far as another 18 to 20 or 22 private insurance concerns are concerned, they will be having 1 or 2 officers in a state. No branch officers for them. That will have a lot of prejudice. And what would be the prejudice that would be cast if it is not in the place of occurrence of accident or where defendant resides or plaintiff resides? Any other place. In fact, for sake of convenience, some claim petitions were also filed before other MACTs. Normally, the tendency is to see that a judge would grant more compensation, more humanistic, and the parties also may choose such an MACT. In fact, ultimately they want to get good compensation. I have no grievance as far as grant of good compensation is concerned. But what would be the prejudice? And in fact, the prejudice would be if an insurance company is already made a party by claimants, and if you expect me to plead and prove negligence of claimants or no negligence on the part of insured vehicle, I have to bring that person, bring those witnesses and take them to a place, an unknown place. If it is a place where accident took place, I can collect information, and you can also take a driver. But to an unknown place, if you are filing it at a place where, in fact, claimant wants, that may cause prejudice. That is what personally I feel. In fact, ultimate role, I agree that it is duty of insurer to satisfy the decrees. But in rarest of rare cases, when Supreme Court would indicate that negligence is the species to grant compensation, contributory negligence also could be agitated by an insurer. Lead evidence, and with regard to quantum of compensation also, in most of the cases, we feel that they are handicapped in not establishing that a misrepresentation is committed. And in almost all cases, in my experience, say 47, 48 years, I feel that there will be an interest to get good compensation. Somewhere some misrepresentation would be there with regard to the expenses incurred for medical treatment or conveyance or for disability or these things. Some exaggerations would be there. Those exaggerations, whatever is projected by claimants, that could be seen by MACT members. In fact, there the role of MACT members would be much more than an insurance. And the insurance company, even if it is not participating, the judges would be entitled to direct insurance company to pay the compensation. Therefore, what inquiry would be. Whether I could clarify.
Thank you so much, sir. That was a very interesting point, the difference between a noticee and a necessary party, that the insurance company is not a necessary party, rather it is a noticee, and the elaborate presentation on the topic. Now we have Ashok Priyadarshi sir from Patna High Court. His topic is, he has joined us. His topic is calculation of just compensation and quick disposal of cases. I will request Mr. Priyadarshi to continue to make his presentation, and so much. And I thank Krishna Swami sir to be with us for this time. And if he can continue for this session, that will be fine. Thank you, sir.
Thank you. Thank you.
Good morning. I believe you can hear me. Good morning.
Yes, sir. Yes, sir.
You are audible, sir.
I'll take you to, basically, I find is that the tribunals have to decide the compensation in a correct manner, and that is satisfying to both. That is to the claimants and the person who is paying. Therefore, virtually what we have to see and decide before we come up to that position is that what is to be looked, what is the purpose behind it. That is says that the purpose, that is settlement of claims arising out of the accident. Therefore, it has to be as per the Motor Vehicle Act of 1988 and its rules. Then the second part which I have tried to find out is, with looking into the Supreme Court judgment in 2019, that is Alka Shukla versus Life Insurance Corporation of India, AIR 2019, Supreme Court, page 288. Considering Union of India versus Sunil Kumar Ghosh, AIR 1984, Supreme Court 1737, wherein they have explained what is accident. And basically what they have stated is that accident is an occurrence which is not planned and it is in a certain condition. But for bringing it within the ambit of a motor accident or for payment of a compensation, it has to be looked into that in cases of injury, the Supreme Court in this latest judgment has said that the accused must sustain a body injury. The injury must solely and directly result from an accident. The third is the accident must be caused by outward and violent visible means. The insured must solely, directly, and independently on all other causes result to a death or an injury. And overall, it also says that the meaning itself says that it should be accidental in nature. Therefore, the tribunal first has to look into whether the claim is based on the injury part or the death, and whether it has been caused by an accident and by a negligence. So this is in 2019, the Supreme Court has placed it in its own explanation that what should be the accident mean, and it has considered the all over India judgments on the same, and two judgments of the Patna High Court also, wherein they had stated that where they had differed, that in cases of injury or in death due to accident, there should be a violent and visible means, which was deferred, but the Supreme Court has now said that no, this is necessary. So when we have taken into the but when we have considered that what is accident, now for the tribunal, it has to take into consideration while deciding various other laws. According to me, it has to take into constant view that the laws which has to be considered while deciding a claim case are as follows, which are as follows. One will be the Indian Contract Act, because under the Motor Vehicles Act also, a person who owns a motor vehicle comes in contact with an insurance company, as insurance is compulsory under the Motor Vehicles Act. Therefore, there is a contract that he will indemnify the liability on the owner. Therefore, it is very clear that the Indian Contract Act comes into play. Next, according to me, is the Negotiable Instruments Act. As by the Negotiable Instrument Act, the owner of the vehicle pays the premium, and that is basically by check. Therefore, check is a negotiable instrument. It becomes necessary, and if the check bounces, then the person who has issued the check, the tribunal can take into consideration that he has violated the negotiable instrument also, which can be considered. Then comes the Insurance Act, because the insurance company is the indemnifier, and under the Insurance Act, the terms of the insurance has to be looked into, and the law itself settles that if there is a contract according to the terms of the insurance, then only the indemnifying can be done. So the court has to consider also the Insurance Act. The fourth point comes up, Interest Act. The interest is payable on the award made on the amount which has been considered to be paid. Now, what should be the rate of interest? The law is very clear that where the interest is not specified, the Interest Act comes into that it will be according to the rate of interest given on a fixed deposit. The fixed deposit, and the Insurance Regularity Development Authority makes it clear that if it is not paid within time, 2% may be added on the interest which is specified. The next thing we have to consider is the Code of Criminal Procedure, because an accident is recorded, and that is under the Criminal Procedure Code, and the other parts have to be looked into. Therefore, we had no definition earlier for grievous hurt, but in the 2019 amendment, it has been accepted that grievous hurt will have the same meaning as per the Indian Penal Code. Therefore, it becomes very, very interesting, and it has to be looked into, that what is the procedure to be adopted is not only the Criminal Procedure Code, but the Code of Civil Procedure also, because it decides compensation. And there the notices have to be issued to the other persons and others who are involved. Now, a question had come up, which the Supreme Court in its latest judgment, I have already supplied you the list of the judgments, has clearly stated that the insurance company, according to me, becomes a necessary party because it's an indemnifier. And the indemnifier has a right also to defend itself, whether it is in a position to pay or not. And if not, then the liability will surely be fixed on the owner of the vehicle who has met with the accident or has caused the cause of action. The next comes up, according to me, is the Indian Evidence Act, where the evidence have to be recorded as per the law, looking into the case in the present status. Next is Employees Compensation Act, because in accidents the drivers die, even the khalasis die, the cleaners die. Therefore, Section 167 of the Motor Vehicles Act make it specific that they can claim their compensation under the Employees Compensation Act as well as under the Motor Vehicles Act. And then in some of the judgments, it is very much clarified that it will stick to those persons only who are employed, and the insurance companies raise always an objection is that here the liability is limited because the person has paid only a certain amount covering the employed driver. Therefore, it cannot go beyond that. There are judgments which supports them to that extent. Now, coming up to the next is the Hindu Succession Act. Why? Because the claimants who will be coming before the tribunal will be dependents, and when they are dependents, on that basis is whether they come within the definition of dependents or not, and others has to be looked into. Similarly, under the Indian Succession Act. And overall, when we make a study out of it, is when the Fatal Accidents Act is to be taken into consideration, as before this was added into the Motor Vehicles Act, according to me, in 1939 Act, these type of claims were decided under the Fatal Accidents Act, which talk about multiplier, consortium, and others, which is to be paid. And overall, last but not the least, that is the Insurance Regularity Development Authority, which sets up responsibilities on the insurance companies, because if they do not cooperate, or if their assessments are wrong and others, and they make a wrong statement, the Insurance Regularity Authority can also take steps to decide that. Now the point comes up before we come to a conclusion is the role of the police when an accident takes place. Therefore, Section 158(6) of the Motor Vehicles Act of 1988 comes into play. It very clearly states that the police will report within 30 days from the date of occurrence to the tribunal, and if it is not done and a person files it, according to me, the report of the police can be called by the tribunal, and by using section 169(2), which very clearly states that the tribunal has all the powers of the civil court for calling any witness, assuring that the documents are presented to it before it is decided. Now, the next part, which is which the Supreme Court has explained in Vimla Devi versus National Insurance Company Limited 2018 Supreme Court 1140, says that it was added by the amendment in 1994. So it casts a duty on the officers, and they cast the duty on the officers to forward the documents which are necessary for the settlement. Therefore, the tribunal gets an opportunity to look into the FIR, which has been lodged for the said incident, what the accident took place in what circumstances. Similarly, looking into this section, the Patna High Court has also, in Srimati Rekha Devi versus Shyam Sundar Singh 2019 2 PLR 563, has casted the duty on the police and said that if it is not sent by the police to the tribunal may utilize its power under section 169(2) for making it applicable into that. Similarly, this part is found under the Central Motor Vehicle Rules, rule number 159. And the Supreme Court also has expressed its desire that it should be done at once. Therefore, we find it in the new amendment of 2019. They say that it will act, and the tribunal will receive those documents as soon as possible. Therefore, in some of the cases, the Supreme Court has branded the report of the police as AIR, that is Accident Information Report. And in the very sense, the Supreme Court has very clearly stated and said that the expression is there as soon as, means that it should consummate the action, that as soon as it receives an information, the police officer should transmit its findings and the FIR and others to the tribunal into action. Therefore, now the question arises: what is to be sent by the police officer to the tribunal? It is very clear that is this A, certificate of insurance; B, the certificate of registration of the vehicle; C, the driving license; then FIR, medical certificate of injuries, or post-mortem report, or the death certificate. And very clearly it has been stated in case of transport vehicles, certificate of fitness referred to in section 56, and the permit relating to the use of the vehicle. Further, it has been said that the observation of the police should be very, 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 very clear. That's why it is said that they give a final form, or they allege that what is the type of the accident which is taking place. Now, the question which arises in one's mind is that what is the need of the FIR? Can it be ignored? The Supreme Court very clearly in National Insurance versus Rattani and others, in AIR 2009 Supreme Court 1499 has stated that an FIR is a part of the claim case as it assures that an accident has taken place and the nature of the accident. Therefore, it cannot be ignored. So we have to be very particular that the FIR cannot be ignored. Now the negligence. Now what is to be determined, and from where we get it? The FIR itself says, and it shows that an accident has taken place. The other part is that the negligence has determined is is also to be determined on the statement of the witnesses. Now, a new thing had appeared, that who is a legal representative? This question had always come up, which comes up to the court. The Supreme Court has answered this in Munford Brothers versus United India Insurance Company in the year 2014, AIR 2014, Supreme Court 1550, which clearly states that the legal representative is the person, just like here, a monk who was a member of the Munford used to work and used to stay with the you can say with the brothers of Saint Gabriel, and he used to contribute. Now, by his death in the accident, the organization could not get more money because the contributor had died. And when the claim case was filed, then it was made very clear that yes, the Munford brothers become a legal representative of the deceased who had died. And similarly, when we look into various other cases, questions come up whether brothers and sisters will be considered as dependents. Lately also, the Supreme Court in its decision has come up and has decided, the point is that there has to be an evidence. There has to be an evidence with regard to that what should be the there have to be an evidence that these brothers and sisters were dependent on the deceased, and if not, then they become the liability of their father or the person with whom they are staying. This has been very much clarified in the latest case also of the Supreme Court in 2020. In 2020 also, that there has to be an evidence, and unless there is no evidence on this regard, this cannot be taken into consideration that whether they are dependents or not. Now the question comes up, when we look into this, then who is the next, then who will be the claimants? While deciding the claim case, we have to look into the claimants will be the wife, the children. Then it says the parents, if the father proves that he was so wholly dependent on the deceased income, he also becomes a claimant. Then minor dependents, and now the newly added is the legal representative. Now coming up to the next part is, which I had already stated, that father, the Supreme Court has stated, has his own income and will not be considered as a dependent, and mother will only be considered. But in the latest in 2020 judgment, it has been made clear that if they are able to prove, then they can also be considered. Then they can also be considered as a dependent. Similar is the case with the sister. If she is unmarried, and if it is looked into, then it can surely be considered that the sister also becomes a dependent if she is unmarried and she has no other earning. Therefore, the brother, she can become a dependent on the brother. Now coming up to the next part of it is that it is now very clear. Now it is very clear that the petition has to be filed under section 163A, but under the new act, which has not yet been implemented, implemented for no fault has been deleted. Then comes section 166 of the Motor Vehicles Act, when the petition has to be filed when it is a fault case. Now, then what is the status? The question comes up that in the present position, even after being, because it stands deleted but not implemented, section 140 remains. Section 140 remains as a sign of interim compensation. And interim compensation is rupees 50,000, which is adjustable from the main. Now, coming up to the question is with regard to petition filed under no fault, that is under section 163A. The amendment made in the act and by the notification of Ministry of Road and Transport and Highways, notification dated 22nd May 2018, it has been very much made clear with effect from 1st of January 2019 that if petition is filed under section 163A, the minimum compensation will be rupees 5 lakhs, looking into the living cost and others. And similarly, when we look into a case of permanent disability, it will be rupees 5 lakhs plus the percentage of disability. And it has been very clearly stated that no compensation with regard to injury will be less than rupees 50,000. So these are still being used as the new act has not been implemented, and therefore the pending cases have to be decided on the various aspects. Now, coming to the next part, which I will like to talk to you is regarding certain points under the new act which has been enacted, which can be taken note of. Section 140, entire chapter relating interim compensation, that is chapter 10, has been omitted or deleted under the new act. Now the interim compensation has to be looked into on the basis of the rules framed, which is awaiting. Therefore, section 140 is still in play. Then comes up section 145, C, D, and I, wherein grievous hurt has been explained, similar to that of section 320 of the Indian Penal Code. Then D, it is hit and run. Hit and run accident, an accident arising out of use of a motor vehicle or which the identity cannot be ascertained. For this purpose, the third party will also include the government and the driver of any of the working of the transport vehicle. It will be, they said, he will be considered as a third party. Then section 147 has also been amended, wherein we still pay with regard to future prospect and others. Now it is being looked into, saying that at the time of force for the purpose of the third party insurance relating either to death of the person or grievous hurt, the central government shall precise a basic premium and the liability to be fixed accordingly. Similarly, then under section 149, an amendment has been made, and section 150, driving by the name person or any persons and duly licensed who have been disqualified of holding has been looked into, and the liability has now been fixed. Let us see when the new rules come up on basically on the owners, and this will be a good ground under which in which the insurance companies will like to take cover thereof. Then under section 166, this time another a limitation has been added, which was deleted under the 1994 Act. And the Supreme Court had to pronounce a judgment in Purohit and Company versus Khatun B, that is AIR 2017 Supreme Court 1612, saying that the Act does not provide any kind of a limitation, but the limitation or the time of filing should be reasonable. The question of reasonability would naturally depend on the facts and circumstances of each case. For approaching the Motor Accidents Claims Tribunal, the only jurisdiction indicated is initiating a proceeding after lapse. See, the person had come after 28 years. They said that 28 years is enough, so it cannot be done. Taking this into consideration, in Musmat Gayatri Devi versus Kameshwar Prasad 2019, 1 PLR page 652, the Patna High Court dismissed the claim case when it came in appeal because it was filed after 13 years. And they said the delay itself has not been considered, has not been explained, neither considered by the tribunal. Therefore, the claim is said to be, even if the sense of the claim for living and surviving claim, this has to be with regard to living and surviving. It goes to show that whether the person, if the person was injured, he could not approach the court, he was hospitalized and others, these are limitations which has to be looked into. Then, as I had stated earlier, Evidence Act also comes into play that therefore the Supreme Court in very clearly is in Faheen Ahmed versus United India Insurance Company Limited 2014, 2 Supreme page 633 has stated that the user of the vehicle has to establish by cogent evidence that this was the vehicle which was involved in the said accident. And then it is then in one of the evidence cases was a very interesting, which I will like to share with you, is that a person filed a claim case and he showed, and his age was shown in the claim petition as per the postmortem report as 46. But when the documents were called and looked into, his service records were found that it was 64, not 46. Therefore, the Patna High Court very correctly, according to me, held that since the evidence deduced by the claimant against his aforesaid case is not admissible, so no evidence can be given against the pleading. So the pleading has to be very, very clear, and the defense has to be taken. And when the persons produce the documents for the amount to be claimed, then it came out to be clear that the age stated was wrong, and then it was decided that the declaration has to be in accordance with the documents which are to be looked into. Then it says the only way by which the document could have been proved is what? By producing the author of the document. Here in this case, the doctor who had assessed the age as 46 should have been asked to appear. That's how he has said. And the document shows that the person had retired and he was receiving his pension. And this was this was the aspect which would have decided the crux behind it. Therefore, it was very, very much made clear that in Rajesh alias Raju versus Raghuveer Singh, AIR 2008 Supreme Court 2396, that the author of the document should be examined and it has to be looked into. Similarly, under the Evidence Act, and when in bringing in evidence, the Supreme Court lately in Muhammad Sadiq versus the National Insurance Company Limited in 2020, 0 Supreme Court page 38 has says to prove contributory negligence, there must be a cogent evidence. In absence of any cogent evidence to prove, the plea of contributory negligence, the said doctrine of common law cannot be applied. So it makes it clear that the evidence has to be led to be proved that what is the real contention behind it. Similarly, to proving that whether the person was a dependent or not, whether he had lived, whether the family had a loss because of the earning or not, has to be taken into consideration. Now, coming to the point of adjudication of the claims, therefore, we all know that it has to be done according to the rules that will come up as Jharkhand Motor Vehicle Rules and Jharkhand Claim Tribunal Rules. Has to be taken into consideration in your state, and the tribunal has to look into that what is to be there. Now, the question for settlement comes up is what should be the content of the claim petition and what is to be established. Therefore, the Supreme Court in Sunita versus State of Rajasthan Road Transport Corporation and others, AIR 2019, Supreme Court, page 994, has very clearly states that the claimants merely to have to establish that the case on the touchstone of the preponderance of probability stands proved beyond a reasonable doubt. Therefore, FIR becomes necessary. What is to be looked into has to be seen. The police inquiry becomes necessary, and then the tribunal, coming into the concept, say the Supreme Court states, stands to prove beyond reasonable doubt. Therefore, the tribunal doubt, and to see that the compensation does not go into the wrong hand, and the standard of proof before reasonable cannot be applied here. It has been clearly stated. Now, a question came up before the Supreme Court. Again, with regard to the claim petition, our mother came up to claim for a person, alleging that he was my son. He died in an accident. But it was found that he himself was driving and he had stepped into the shoes of the owner because he had borrowed that vehicle. Therefore, the Supreme Court in National Insurance Company versus Asalata Bhaumik, it became very, very clear, and some of the cases have been decided in Patna High Court also. And lately, also in 2020, in 2020, the Supreme Court has clearly stated that the borrowers of the vehicle, as they step into the shoes of the owner, will only be liable for PA, that is personal accident insurance, which they had taken for, which is compulsory and which has been taken by the parties into. Now, as we all know, the application has to be filed as per the rules, as per the forms provided in the rules, and the annexures which are there already. There is no need of a repetition when it says that but still that the FIR in respect of the application, medical certificate, postmortem reports, then it gives the tribunal the power to examine the application. Then summary dismissal of the application option, also the power is there, because it says that no sufficient ground found, that there is no sufficient ground that he is, or it proves that he is not a clerk. Then what is to be done? And then it says notices has to be issued to the opposite party, wherein the owner of the vehicle, when he appears, he assesses, he says, he submits that his vehicle is insured. Therefore, it says that the insurance company becomes a party to it. And as we have already looked into that in Sila Datta's case and in some other cases, it has been very much clearly clarified that the indemnifier should also be heard. Therefore, the opportunity is directly given when in the natural justice to the insurance company to either accept or to deny. Therefore, under the new act, it has been made very clear that the information of the accident is to be sent to the insurance company. Under the new act, that the insurance company, after investigating the whole thing, places its stand, and if it is ready to pay even the amount which is to be paid, and if the parties do not accept it, the tribunal will adjudicate the matter. This will be a very good aspect of consideration of compensation when it stands implemented by the next notification which is going to come, as only the penalties have been defined and looked into. Now the question comes up is that whether a claimant has made a claim, it is to be paid or not, or issued as to be framed or not. Therefore, the Supreme Court, and in Yalva's case, in AIR 2007, Supreme Court 2582 made it very clear that the tribunal has to frame the issue, and the issues have to be, all the issues have to be decided. And then similarly, in AIR 2010, Supreme Court 2591, Bimlesh versus New India Assurance Company, accepted by Patna High Court also here in 2019, 2 PLR 563, Srimati Rekha Devi versus Sam Sundar Singh. It was made clear that all under Section 168 of the MV Act, the trial is summary procedure, and the claims tribunal has to follow not a contemplated or the controversy arising out of the case, but decide decide the case in a piecemeal. Therefore, it has to decide, it has to make out that what were the issues involved. I can point out to you is that paragraph 5 of this judgment is also very clear. AIR 2010 Supreme Court 2591, Bimlesh versus New India Assurance Company Limited, while deciding the issues. Now it comes up that what is to be done. Then, considering this judgment, the high courts here, and even I find that your high court, the Jharkhand High Court, has also laid a stress that there is a mandatory provision for framing of issues. Therefore, the issues must be answered, and it should not be in a piece. Now coming on the bifurcation part. Bifurcation, I say, is that the accident leads to injury and to death. Therefore, the tribunal, what has to fix. It has to fix the age of, it has to decide and fix the age of the deceased, the income of the deceased, and the number of the dependents. Now coming up to the other aspect of it is that what are the steps to be taken? Steps the Supreme Court has already explained in Sarla Verma versus Delhi Transport Corporation, now confirmed by in National Insurance versus Pranay Sethi, that the steps have to be considered. Those are: step 1, ascertaining the multiplicand. What should be the income of the deceased as per annual should be determined. Second, ascertaining what is the multiplier. Then what should be the multiplier given to the applicant, that is to the income which is determined. And the third is, after giving the statutory with regard to loss of estate, loss of consortium, and funeral expenses, then what should be the actual compensation? The tribunal has to decide on this aspect. Now, the question, according to me, comes up: what is the questions to be determined so as that it comes up as a just compensation, as the Supreme Court has very clearly indicated that just compensation is to be taken into consideration while we are doing it. So it was first taken up in Sarla Verma's case. It says addition to income from future prospect. In Sarla Verma, they gave it only to the government officials up to 50%. They said 50% of the actual income, and by the increasing of age, it was to be the future prospect was to be brought down. I'm not going into that detail because that has been considered in national insurance versus prenacity. And in prenacity, everything has been made very, very clear what is to be done. Then the next question comes up is, what should be the deduction on personal and living expenses? But for the first time, the Motor Vehicles Act made it clear that it should be 1/3, but this judgment made it clear that the personal expenses will depend upon the number of dependents. Therefore, it said 1/3, where the number of dependents final number is 2 is 2 to 3, 1/3. 1/4 when the number of the dependents and the family member is 4 to 6. Until the final 1/5 if the number exceeds 6. Now it says very, very clearly is that what should be the correct multiplier. With regard to the correct multiplier, there was difference of opinion between in the Supreme Court. So this judgment clarified that if you look into Sarla Verma's case, where the selection of multiplier is given, the fourth column is to be accepted. That is for 15 to 20 years, 15 to 20 years, 18, 21 to 25, 18, 26 to 30 years, 17, then 31 to 35, 16, 36 to 40, 15, 41 to 45, 14, 46 to 50, 13, 51 to 55, 51 to 11, 56 to 69, 61 to 65, 6. And then above that it said it will be 5. But they kept it blank from 0 to 15 years, which was answered in Reshma Kumari's case, wherein it was said that let that be 20 without any personal, the multiplier to be 20 without any personal deduction. So coming up to, when we look into Reshma Kumari, this was 3 judges earlier. Earlier that was Sarla Verma was 2 judges. Now 3 judges in Reshma Kumari versus Madan Mohan, 2013, 9 Supreme Court cases, page 65, very clearly stated that the petition, first time it had come, for no fault should be under section 163, not in 140 because it becomes a part of 166, and where the amount given is adjusted. And as I have described earlier, that now under section 163A, the minimum compensation which is to be granted is rupees 5 lakhs, which has to be taken into consideration, looking into the buying power and expenditure aspect of that feature. Now coming up to question which comes up, which the Supreme Court answered, if the person had no income, there is nothing coming up. That what was the income of the person? Then in Nita versus Divisional Manager MR City Kolhapur, it was clearly stated. That is 2015, 3 Supreme Court cases, 590. wages is to be taken into consideration. The wording says that in absence of any salary slip, nature of job, wages under the Minimum Wages Act ought to be considered, and agriculture income of the deceased to be added, and the interest to be granted on the total amount. So this is what the Supreme Court laid down, where there is no specification of income. And in conclusion, in Reshma Kumari, it was clearly stated that no changes can be made, only the changes from 0 to 15, the multiplier will be 20, which was not given, not given in Sarla Verma's case. Now coming up to the consideration of compensation as per National Insurance versus Prenacity, AIR 2017, Supreme Court 5157. The basic importance in this case is that the 5 judges confirmed the 2 judgments, that is Sarla Verma and Reshma Kumari, and further added and enlarged the concept of future prospect. It says determination, self-determination. It says persons who are self-employed or on a fixed salary, that is not in government servant, when below the age of 40, the addition will be of 40%. And if 40 to 50, 25%. And if 50 to 60, the addition will be 10% of the established income to be. Then on permanent job and in government job, 50% with regard to 40 to 50 years, 30 between 50 to 60, 15 against the actual income of the persons to be made, and the deductions remain the same, which is said 1/3 when the members of dependents are 2 to 3, 1/4 more 4 to 6, and 1/5 when it 1/5 when the dependents exceed 6 in number. Now coming up to the other aspect is, the question has always come up is with regard to child. The child part was being looked into. Therefore, we look into Reshma Kumari and others, which says multiplier was to be of 20. Therefore, considering that the minimum, the statutory amount which was to be awarded basically for the person having no income, 15,000. If we take 15,000 and multiply with 20, and for the rest, if 50,000 is given, it becomes 3,50,000. This was confirmed. This becomes confirmed by the Patna High Court judgment also. It said that yes, it is correct. But even this is absolutely correct for children and others, but a loud thinking has to be given with regard to the amendment of the 2000, which has come into 2009, that the compensation with regard to death, that should not be less than 5 lakhs. Therefore, this has to be taken into consideration, that the statute now provides 5 lakhs, but in reality, this is the amount. But as the second schedule stands amended, I should also say that it should be amended to the extent of rupees 5 lakhs. Now, what will be the state? We find also that what will be the status of persons who are owners of the vehicle. Sometimes they come up for compensation. The Supreme Court I have already stated, the Supreme Court had stated they cannot go beyond personal that is known as personal accident claims, which they take it from the insurance company. And if the person has borrowed and he is responsible himself for the said accident, therefore he will not get more than that for which the premium has been paid. If the premium is paid for rupees 5 lakhs, 5 lakhs. If it is paid for 2 lakhs, because it has to be decided as per the premium paid. And similarly, in the latest cases also, it has been stated the borrower is not a third party because he steps into the shoes of the owner. That has been been clearly accepted by the Supreme Court in its latest decision in 2020 also. Now, in cases of injury, where the injury has to be considered, it says injury is to be compensated instead of full. It has to be compensated, and it is said that the earning use what a person used to get the earning, and it has been very much been clarified in the amendment also, which the Supreme Court states that now the minimum amount will be 50,000, and when there is a permanent disability, 5 lakhs into percentage of disability as specified in Schedule 1 of the Employees Compensation Act. Because that Schedule 1 tells the tribunal that if of this injury, this grievous injury, or the permanent disability has been caused, the person will lose what? And what will be the income he will be getting is to be decided accordingly. Now, coming up to this aspect of the injury, it is divided into two parts: pecuniary and non-pecuniary. This has to be looked into. Therefore, pecuniary damage, expenses relating to treatment, hospitalization, hospitalization, transportation, nourishment of food, miscellaneous expenses, loss of earning while the injured would have made, it would not have been comprising the loss of earning during the period of treatment, loss of future earning or according to permanent disability, and future medical expenses. For the best, now we have the latest judgment, that is Kajal versus Jagdish Chand. This is 2020 Supreme Court section 110, which clearly states that these has to be paid, and next comes up is damage for pain, suffering and trauma as a consequence of injury, loss of immunities, and loss of expectation of life is also to be considered. And as earlier stated, that future earning and then the future medical expenses, if there are, is to be paid. And for the period, it is said that 52 weeks is to be considered as per the Employees Compensation Act as treatment that has to be considered and to be paid. Now, the assessment of future loss of earning and permanent disability, this has to be taken into consideration, that how it is calculated, and whether the person loses his job, it will be treated as permanent. Just like a driver has lost one of his legs, this will be treated as permanent disability. The disability, looking into the similar points into it. Now, the Supreme Court has taken up a very interesting case, and had said that the percentage of permanent disability is expressed by the doctors with a reference to the whole body, not of parts. Therefore, a case came up before the Supreme Court in which a person claimed that he had an injury of lower limb by 45%, 45 with a 45% and then 60% permanent disability to the right hand, 80% disability to the left leg. And it does not mean to the extent that the whole body cannot be more. If we calculate, it becomes 140%, but it cannot be more than 100%. And looking into the 100% of the capacity, then it will be treated as permanent disability. Now, the question comes up is that what is the future prospect given? Some of the tribunals have wrongly assumed to an extent the corresponding loss of earning has gone up. The injury will be of the two. If it is temporary, then in temporary the expenses, which in Kajal's case it has been clearly stated that the treatment of the amount will be given. It has to be ascertained what was the loss of earning, the capacity and others. But before the tribunal, basically it is placed this, that this is the nature of the injury we had, this is the report given, but the other part, whether temporary or not, is not proved, neither brought on record, and neither the doctor who has given or the board which has given the certificate of disability is examined. Therefore, a wrong decision is taken, which we have to look into. Now, this Kajal versus Jagdish Chand case has taken note of Rajkumar versus Ajay Kumar, which is AIR 2012 Supreme Court. Sorry, it is 2011 1 Supreme Court cases 343, and Sanjay Batham versus Munnilal Parihar 2012 Supreme Court page 459, which clarifies that while ascertaining the loss, these considerations has to be taken in consideration, and overall it has to be seen that the claim case is not a bonanza. It has to be a compensation. And similarly, while many come up with cases which I had really left a little, was composite negligence and contributory, which has been very rightly explained by the Supreme Court in AIR 2008 Supreme Court 1646 TO, that TO Anthony versus Karvakaran, wherein it says that the person has a choice. It's a case where two vehicles have met with an accident, the claimant has a choice to claim the compensation from anyone it seems to be correct, and others. Now coming up to it is that under the new amendment, as we have seen, that it is now talking about the real aspect of the compensation, and it should not be a bonanza, and overall it should not be such. It should not be such that it is to be taken in a way that that the person feels that he has been deprived. So it has to be a just compensation, and this is the role of the courts to see to that extent, that it to see to that court that it stands that it is clearly on the said basis, and a just compensation is paid. This is in short, which we can say that how the tribunals should act on determining the claim cases to and for awarding a just compensation to the person claiming compensation under the Motor Act, Vehicles Act, an injury or death due to motor accident. This is in short which I could state to you in this, and I'm ready to answer the questions, if any, which are put to me.
I will say some of them are not in the question form, rather they are responses, but I will draw your attention to those so that you can respond on that. So the question follow.
The new rule of Jharkhand, the new rule in Jharkhand has been notified. So the question is whether at present the Jharkhand MACT rule 2019 is the only rule governing cases in Jharkhand.
Yes, till the central motor vehicle rule comes into play, because similarly in the state of Bihar, the Bihar motor vehicle rules is being applied, and rules basically explain how the petition is to be filed, and what is the court fees to be paid, and what are the necessary documents is to be filed. Those are the basics which have to be considered till they are finally set aside by bringing in the central rules, and after it being adopted by the Jharkhand state.
Sir, the next question is from Sri Amresh Kumar. Is there any provision to grant compensation from the date of accident when the person died and legal representatives filed compensation case?
The answer is a big no. Why I say no is that my friend is talking with regard to employees' compensation, where it's for employees it starts running from the day they meet the accident, because they are employees and the relationship of employer and employee is there. But in this case, a person is a third party, and when he claims a third party, he claims it before a court, or we can better it is said before a tribunal. And therefore the Supreme Court in various judgments have also stated that it is from the date the accident claim has been filed, the interest is granted.
Sir, another question has come from Sri Sanjay Kumar Singh, ADJ2 Kodarma, that usually MACT tribunals fix a certain date for payment of compensation with interest. But can there be a scheme that in case there is failure to pay compensation with interest by that day, the judgment debtor be liable to pay an enhanced rate of interest?
Every judgment shows, even they have said that it is a penalty under the IRDA Act. If it is not obeyed, therefore 2% extra interest is added. And the person, if the person does not get the money, he can go in for execution. And only thing which we have left is, because I left it for the question and answer basis, was pay and recover. If there is question, I can answer that. Yes.
Thank you so much, sir. Now you took out this time in it. It is nice to see you after so long, but we wish that normal life resumes soon, so that we can have you here in person and have a more involved interactive sessions with you. Thank you very much, sir. Thank you, my brother,
Thank you very much.
participants. Thank you so much.
Thank you.